welcome everybody. It is just after past, so we probably will get going. What we're hoping to do today is talk about secondary victim claims after the Court of Appeal's decision in Paul. The plan is that I'll start with a brief introduction, as you can see. Gareth will talk about some of the previous authorities and where we got to before Paul, and then I'll run through the judgment of Paul, where that takes us, and then hopefully we'll finish with some practical takeaways and something you can scribble down with a bit of a checklist that might help you with secondary victim claims. So where we start then is briefly, what is a secondary victim? And hopefully we all know that that's the person who suffers psychiatric injury as a result of witnessing a horrific event. So it's not the person to whom the horrific event happens necessarily. They are a witness to it. And we're talking about psychiatric injury. The next question is, why does this pose difficulties in clinical negligence? Some of you may have practiced in personal injury, or we may have some personal injury practitioners with us. And certainly secondary victims are less complicated when it comes to PI. But in clinical negligence, the difficulties that the courts have had is because of the delay in time between the breach of duty and then the horrific event. Now, that's usually because we talk about misdiagnosis cases. So there is a breach and we don't find out until some later when we see the consequence to that. And so, as I said, what you can expect from us is a summary of the law and hopefully some practical takeaway points. So with that, I'm going to hand over to Gareth.
Thanks, Megan. On just this Sunday gone, Liverpool and Nottingham Forest played in the FA Cup, and it was the first time they'd done that in the FA Cup since 1989, when they were playing in the Hillsborough part of Sheffield, at Sheffield Wednesday's football stadium. And the game had to be abandoned because of crushing in the crowd that led to what's now, I think, 97 people have died as a result of. That tragedy, the Hillsborough tragedy, has led to all sorts of legal ramifications. And one of them is the case of Alcock. There are a number of decisions following this particular event, but the one that we're going to focus on for today is Alcock, because it sets out, both in two of the different Law Lords' opinions, but in particular we're focusing on Lord Oliver here, sets out what are called control mechanisms. If you are representing or defending a claim from somebody who is contending that they have suffered psychiatric injury by reason of witnessing a shocking event to a loved one, then they have to fit within these control mechanisms. There is a later case, I think it's Frost, I could be wrong, but I think it's Frost, in which it was said, well, since Alcock, the idea of principle in this area has been abandoned. And the reality is, it's a piecemeal, incremental approach by the courts in an effort and an attempt to try to do justice to those that it considers should recover as secondary victims and those it thinks that should not recover as secondary victims. We're not focusing today on anything but 3, 4, and 5, really. You'll see there from the slide that the third control mechanism, thirdly, that the plaintiff in each case was either personally present at the scene of the accident or was in the more or less immediate vicinity and witnessed the aftermath shortly afterwards. 4, the injury arose from witnessing the death of or extreme danger to or injury and discomfort suffered by the primary victim. And lastly, in each case, there was not only an element of physical proximity to the event, but a close temporal connection between the event and the plaintiff's perception of it. Those are the 3 things which, in the course of the clinical negligence claims that we're going to look at, and in particular when we get to Paul Polmear, that cause particular difficulties and problems. Because, of course, in the Hillsborough tragedy event, what happened was a horrific event for everybody within the stadium to have witnessed, for loved ones to have learned about, either via television or radio or by being told about it. And the event itself, the horrific event, followed very shortly after the negligent act of, in that case, the South Yorkshire Police Force in terms of crowd control. When we're dealing with clinical negligence claims, of course, that's rarely the case. It's rarely the case that the allegation of negligence against the hospital or doctor or whoever is prescribing the medical treatment leads shortly thereafter, within a matter of minutes, seconds, or hours, to harm of, in the usual case, the patient, the primary victim. It's usually not that case. It's very often the reverse. It can be months and years before the negligence might give rise to actual injury. So those particular control mechanisms in the Alcott case are what we're focusing on. Can you go to the next slide, please, Megan? Thanks. You've seen the headlines. That was Hillsborough, that was Sheffield. We're heading south now, just to give you a bit of a map as where we're going. We're heading south to Somerset. This case is particularly important because it raises its head again with force in Paul and Polmear. Taylor and Somerset, very briefly, the facts are that Mr. Taylor had heart disease and he died in 1987 after suffering a heart attack. In the period between when the heart disease was identified and the heart attack occurring, there was admitted failures by the hospital who was treating him to properly diagnose him and treat him for that condition. The breach, therefore, by the staff at the hospital who were treating him occurred many months prior to the heart attack that led to the immediate medical cause of his death. He was taken to hospital, but he was pronounced dead at the hospital. Mrs. Taylor, his wife, learns of this incident, that he'd had a problem at work, and she arrives at the hospital about an hour later, and she is told of his death 20 minutes later. She's shocked by this news. She goes to identify the body in the mortuary, in part because she did not believe it was possible. And the witnessing and identifying of her husband's body causes further shock, and she thereby suffers psychiatric injury. Can we have the next slide, please, Megan? The claim was, of course, one of secondary victim, and it failed. It failed for two reasons. The decision was that, from Justice Old, that there was no external traumatic event causing the injury or death of Mr. Taylor, and it was certainly not something that was witnessed by Mrs. Taylor. Now, we're going to come back to that concept in time when we look at Paul and Polmear, because the concept of the need for an external event has been undermined by the Law Court of Appeal in Paul and Polmear. It seems to be accepted that there need not be an external event. It can be effectively internal to the patient, to the primary victim. But the second reason that was held why the claim could not succeed was that Mrs. Taylor was told of her husband's death, and then she went to identify him. That was not a traumatic event in any legal sense required to fit within the control mechanisms, and it was not the witnessing of the event caused by the negligence or even its immediate aftermath. It was a good number of hours, or an hour or so after the death. She was witnessing the body in the morgue in order principally for the purpose of identification. And a combination of those factors led the court to find, well, this was not the kind of case which Mrs. Taylor should fall within the control mechanisms for, and therefore the claim failed. That presented a little bit of a difficulty for claims, of course, in clinical negligence. It effectively poses a significant barrier for those who are wishing to establish themselves as a secondary victim in a clinical negligence setting, because it raises the concept of, well, what event might one witness as a secondary victim that could therefore fit them within the control mechanisms, if it's not arriving on the scene at the hospital shortly after, an hour or so after the death occurs, which itself was caused by the failure to treat. So next slide, please, Megan. We're now going to head up north, and we're going to go into Scotland, and it's Glamorgan. This is a really sad case. I suspect most people on this call have read it. In short, this case concerns a 10-month-old baby who became very, very unwell and was hospitalized. There was a failure to correctly diagnose that the baby was suffering from acute hepatitis, and this led to liver failure. There was a gradual deterioration, and the child suffered fits and eventually brain damage. The hospital treating the baby gave differing information to the parents, in particular Mrs. Walters, the mother who was the claimant in this case, as to what damage the child had suffered and what treatment might be possible for him. Eventually, about a day or so, a day and a half after the start of this deterioration of the child's treatment, of the child's condition, a decision was made to end life support, and the child died in his mother's arms. The claim is brought by Mrs. Walters, and it was admitted that the treatment that was provided to the child was negligent. But the trust denied that Mrs. Walters was entitled to claim as a secondary victim. Mrs. Walters succeeded at first instance, and it went to appeal. The key issue on the appeal was, well, what was the event here? What was the event that Mrs. Walters witnessed that caused sudden shock to her that then led to her suffering from psychiatric injury? The Court of Appeal accepted what the trial judge had said when the trial judge had described the event as being something which in ordinary parlance could occur over several days, that an event is not something which happens in a discrete moment of time necessarily, and there can be a number of discrete matters or discrete events within the event. And looking at the progression in time in this case, where the mother woke to find her son fitting, and then the gradual deterioration over that period of time alongside the change in information that was being provided to her from the hospitals that were treating the baby, led the trial judge to find, well, the mother was physically present for much of it, and that was an event that she was sufficiently proximate to. And she satisfied of all the other criteria in terms of actually suffering psychiatric shock, that it was a sudden matter, and of course, the close tie of love and affection. The couple of factors arise from this case that's worth touching on before we move on, and that's, well, Mrs. Walters had to be informed by doctors treating her about what was happening to her son. And a key aspect of the secondary victim claims is the idea of witnessing the horrific event for oneself, and that it is not sufficient to simply be told about something which one might describe as a horrific event, but you learn of it simply by relaying of information. The Court of Appeals said that, well, the trial judge was entitled to find that you can take into account information that is added by reason of, for instance, an explaining by the doctors of what's happening, but it was necessary and important in that case that the mother was present for much of what was described as an inexorable progression of time or events, and she was present for a great deal of it, not all of it. There was a period of time when the baby was transferred from one hospital to another that I think she followed the baby when it was moved, but for much of it she was present, and it was not improper for the claimant, in that case Mrs. Walters, to say, well, I was informed and updated about matters by the doctors, but that was not being informed of the horrific event. I was witnessing the horrific event and learning as I went along from what the doctors were telling me. And another matter, perhaps just to touch upon, is, well, what was the event? What was the horrifying event? And again, on the facts of the case, it was found that it was the entire period was the horrifying event. There was not a single one-off occasion in which it was said that caused the sudden shock to materialize and the claimant could succeed because of it. So set against the Somerset case, it's quite a rather broader range of principles on which a claimant might consider they would succeed as a secondary victim. It imports or involves the idea of some information being given to the claimant and that they can rely upon that information when establishing the knowledge that's needed to then suffer from the sudden shock. And it's a series of discrete events. Whilst, of course, it's described as an entire event, the reality is the baby is ill at one point in the timeline, and of course, unfortunately, dies at the very end of it when life support is taken off. But in that intervening period, there's a lot of discrete events that occur. And the Court of Appeal found that, well, this was a number of events all connected in a seamless tale, And on that basis, the claim succeeded. Next slide, please, Megan. We now head, lastly, before we look at Polmear, to the east, and we're going to Norwich, down from Scotland, where there was what might be regarded as a bit of a brick wall for many claimants, particularly in the context of clinical negligence claims. The facts of this case are not, it is not a clinical negligence case. The facts are that the claimant, the primary victim, Mrs. Taylor, was injured at work when a stack of racking boards fell on her. And that was admittedly due to the negligence of her employer, Novo. Mrs. Taylor was making a good recovery, it seemed, but about 3 weeks later, she collapsed at home and she died. Now, unbeknownst to her, the accident had in fact caused a thrombosis to develop that made its way to her lungs. It caused a pulmonary embolism and she died from it. At the time that she died, she was with her daughter, and her daughter witnessed that. It was agreed, it wasn't an issue, that the daughter satisfied the control mechanisms of a close to unloved affection, that she had in fact suffered post-traumatic stress as a result of witnessing the death of her mother. And the judge found, well, there was one event here. There was one event for the purposes of the case, and that was the accident at work, which had 2 consequences. If we can turn to the next slide, please, Megan. What the employer argued was, well, it might be right that Mrs. Taylor suffered her death by reason of the accident that she had at work, but it was not right to say that she could recover. And the principal argument was because there was a material gap in time between the actual event, the negligence causing the accident at work, and then the death. The trial judge held that the collapse was a new traumatic event, and there was no material gap between that and the accident. So effectively, there had been negligence causing a traumatic event, which was the accident at work, and then causing a new traumatic event 3 weeks later, which was the death. And that because the daughter was present at the time of that second traumatic event, she could succeed under the control mechanisms. That went to appeal before Lord, in particular, the decision by Lord Dyson, and the appeal was allowed. The first point is the proximity question. So the idea of, well, what are we looking at here? For the purposes of the duty between the defendant and, in this case, the claimant, which is the daughter, the secondary victim or alleged secondary victim. The questions are one of time and space. What is the negligence that's occurring by reason of the defendant's actions or inactions? And what is the time or the event that's causing the claimant, the secondary victim, to suffer from the psychiatric injury? And what the Court of Appeal found is that to accept or to allow a claimant to recover on these facts, i.e. where there was a discrete event, which then had separate consequences, the first being the accident at work, the second being the death by reason of the emboli, that would be taking matters too far. It would extend the idea of allowing secondary victims to recover too far. The first thing that occurs, I think, to me, and I think to many people, is, well, how does this sit with Walters, if at all? Because, of course, you had in Walters a situation where there was negligent treatment, which gave rise to a set of continuing events, which ultimately led to the shocking event of turning the life support off for the child. It doesn't perhaps sit that easily, and when we get to Polmear and Megan deals with that, the Court of Appeal acknowledged as much in that case. But the reality is, because of this decision, it's left the law in this situation, which is that claimants now have to establish, for the purpose of a clinical negligence claim, that they are present at the time that the negligence gives rise to the horrific event. If they are not, if there is a delay in time, then Taylor and Novo poses a serious impediment to any claimant who says, well, I was present when the horrific event occurred. That might be right, but if there is a gap in time between that horrific event and the earlier negligence, it's likely the claimant is not going to succeed. In particular, in Novo, I should say, because it comes back again in Paul, the judge in that case, Lord Dyson, referred back to the Somerset case, Taylor and Somerset case, and thought that was particularly important and relied upon the reasoning in that case to conclude that the claim from the secondary victim in this case should fail. Okay, all right, those are the sort of highlighted aspects of the prior authorities. There are many others, we don't have time to go through them all, but those are particularly important. They're relied upon or referred to rather in detail in Paul. So I'll hand back to Megan, who's now going to talk us through that decision.
Thank you. So we have the decision in Paul, Polmear and Purchase. The Court of Appeal heard the case last year and we've got the judgment handed down this year. Each three of the cases involved a failure to diagnose a life-threatening condition, and the primary victims in each case, Paul, Polmear and Purchase, died. In Paul, P suffered a heart attack and died in the presence of his daughters, who were just aged 9 and 12 years old. In Polmear, P collapsed and resuscitation attempts failed. She was aged 7 and her parents witnessed that event. And in Purchase, P, who was aged 20, died in the early hours of the morning, and her mother found her almost immediately after she passed away, about 5 minutes later. In Purchase in particular, though her mother wasn't present, her mother had a voicemail lasting almost 5 minutes, which contained the final breaths of P. So she had to listen to that immediately after the event. So those are the facts that the court were dealing with. And in each case, because we're in clinical negligence, the breach of duty were all about misdiagnosis or failure to diagnose. And in each case, the primary victims were having some sort of medical treatment and the condition was missed. Hence, they suffered the event which caused them to pass away. Now, this is the first time that the Court of Appeal have had to deal with this in the context of clinical negligence. We did have the case of Waters, which Gareth discussed, but it didn't reach the Court of Appeal. So what happened is the Court of Appeal, in their judgment, they give the usual summary of the background to the cases, and they go on to say, well, how do we handle these? The background in Paul is that the claim failed at first instance but succeeded on appeal. And in that case, the appeal judge said, in a case where such an event is the first occasion on which damage is caused, and is therefore the first occasion on which it can be said the cause of action is complete, Novo does not preclude liability. So in Paul, Mr. Paul suffered from type 2 diabetes. He complained of chest pain, and ultimately the defendant didn't perform a coronary angiogram, and that would have detected the problem to prevent his heart attack when he died. And so the appeal court said, well, hang on, nobody knew really that there had been negligence because Mr. Paul was just carrying on with his life. So we were different from Novo because in Novo, the claimant had some immediate injuries from the accident at work. Then there was a gap, and then she suffered her fatal injury, but we weren't there in Paul. And so the appeal judge said, no, nothing in Novo precludes liability in this situation. Then we had Polmear, and Polmear followed the decision in Paul, the appeal decision. Now in Polmear, I mentioned that this was the little girl who was 7. She had been treated for some very unusual symptoms. She was having strange episodes where she was struggling to breathe and she was turning blue. Her GP referred her to paediatrics. She had another referral to paediatrics. And ultimately, ECG monitoring occurred for 2 days, and the paediatrician said, look, there's nothing to suggest an underlying cardiac problem. So in Polmear, P was having ongoing problems, which is different to Paul. But in that case, the judge said, in the circumstances, the question is why should the fact that Esme had suffered non-fatal episodes on previous occasions rule out the secondary victim claim of her parents? It seems to me that Esme's final episode can be appropriately described as a fact and consequence of the defendant's negligence. So in Polmear, the judge said, well, we were having some symptoms from Esme, but it is all linked. And so that's quite different to the decision in Novo, where we did have the gap in time and the court said, no, there is no secondary victim claim. And then we get to Purchase. Now, this was not decided in the claimant's favour, and it was decided before the appeal in Paul. So effectively decided at a similar time that the first instance claim in Paul failed. And the judge in Purchase very strictly followed Novo. In that case, again, P was having symptoms. She attended her GP on a number of occasions, and ultimately she then passed away from what was, I think, a pneumonia. And the judge said, well, hang on, she was having symptoms anyway. The negligence happened before she died, not on the day she died or at the very time she died, and I am bound by this Novo decision. And then the Court of Appeal in their judgment go on to say, well, what do we do about this? We're dealing with secondary victims in clinical negligence for the first time. And I've included this, it's paragraph 12 of the judgment, so it's probably on about page 3. And it's one of the very first things the Court of Appeal say, where they effectively set down their decision right at the beginning, before they even analyse the law. And they say this: for a secondary victim to be sufficiently proximate to claim for psychiatric injury against the defendant whose clinical negligence caused the primary victim injury, the horrific event cannot be a separate event removed in time from the negligence. So one of the first things the Court of Appeal say is effectively, this is what Novo tells us. They pay a little nod to Walters. So if the negligence and the horrific event are part of a continuum, there is sufficient proximity, but Novo is a binding authority. However, again, we're only on paragraph 12 and about page 3. The court says this: I accept there is no logical reason for these rules. However, this is what the courts have done. If I was starting with a clean sheet, I can quite see why secondary victims in these cases ought to be seen to be sufficiently proximate to the defendants to be allowed to recover damages. And since, however, this court is bound by Novo, it's for the Supreme Court to decide whether to depart from the law as stated by Lord Dyson. So right off the bat, we get this huge nod from the Court of Appeal saying, look, before we even analyse the law, we accept we're bound by it, and this is one for the Supreme Court. Now, you all know that. So what did the Court of Appeal actually say? They say, obviously, the question is whether the legal proximity existed between the defendant and the proposed secondary victim. Now, there were a number of counsel in the cases, and collectively they said, well, look, we've got 3 propositions, one put forward by the defendant, one from Paul and one from Polmear and Purchase claimants. And they each said, well, when does the liability become established? Defendant says, the horrific event is the damage completing the primary victim's cause of action in negligence. So if we link this to Novo, what the defendant is saying is at the point that the primary victim first suffers any damage, that's it. That's when their case is crystallised and it's tough luck secondary victim. The Paul claimants say, well, hang on, the horrific event is the first manifestation of damages to the primary victim caused by the negligence. And that's because in Paul, as we remember, Mr. Paul wasn't suffering any symptoms until his heart attack that could be attributed to the negligence at that point. They said, well, look, this helps us. But in Polmear and Purchase, where each of the claimants were suffering some symptoms which were attributable to the negligence and then passed away, they said, look, it's not about the other symptoms. It's about whenever the horrific event occurs. So it's not our breathing problems that we recover from. It's not our symptoms of pneumonia that we're managing with. It's the horrific events, because that's what essentially saved their cases. And the Court of Appeal effectively said, counsel, thank you very much for your analysis. However, it's illogical to drill down into the legal liability and injury caused to the primary victim, because what's important is the horrific event that caused the psychiatric injury to the secondary victim. So what the Court of Appeal are telling us is try not to get swept up into the journey of the primary victim really we start with the horrific event. So whether the secondary victim is witnessing the breathing problems or the cardiac symptoms, the whole premise of a secondary victim claim is about the horrific event. So that's what we're looking at. And then they move on to say, okay, so if that's what we're dealing with, what do we do? And we get another huge nod from the Court of Appeal that says we're not very happy about what we have to decide in the law, we have to decide it in, because they say, if one was simply considering the requirements, so that's the 5 elements from Alcock, and applying them to clinical negligence situations, I think one would say that despite the fact the horrific event took place later than the defendant's misdiagnosis, essentially that's all right and there is a secondary victim claim. But the question is whether the authorities prevent us from reaching that conclusion. Now I include this because it is a huge nod from the Court of Appeal. We know that there's probably going to be a Supreme Court appeal. We don't know when that will happen, I think at this stage. But the Court of Appeal are giving these really big nods that they're quite uncomfortable about the decisions they're making, because it's the first time they've considered clinical negligence. But what they are bound by is a personal injury decision, which is really quite different. I'm not going to recite much more of the judgment. The next slide is just really the deciding paragraph. And all lawyers hate it when people say this, but really there's no substitute for reading the entire judgment. And that's because it summarises all of the cases that Gareth has helpfully covered and some more. And the reason I think it's so helpful to do that is because you get a good background, but you get the feel for why cases were decided in personal injury matters and what the Court of Appeal are hinting at. So Gareth said earlier that we would come back to this question of whether there needs to be an external traumatic event. And the Court of Appeal, when dealing with the case in Somerset, specifically said, and I can say at once that I can find nothing in either McLaughlin or Alcock, so that's really the first 2 decisions, that impose the requirement of a traumatic event that is external to the primary victim in the sense of an outside impact or accident. It seems to me the judges in McLaughlin and Alcock were doing no more than explaining the principles in the context of cases where such external traumatic events had in fact occurred. And so that's the difference we get in personal injury cases. There is an external event that happens to the primary victim, but we don't really have that in clinical negligence. As Gareth said, we don't often have surgeries which go so immediately wrong when the secondary victim is there that it all combines together. And so the Court of Appeal were quite clear that that's not a requirement anymore. And what they also went on to do is cite an extract from a case called Sion. So Lord Justice Peter Gibson dealt with the case of Sion. And it's really not given much nod in the judgment because it isn't particularly helpful. It's not binding on the matter. But what he said is he saw no reason why a breach of duty causing an incident involving no violence or suddenness, such as where the wrong medicine was negligently given to a hospital patient, could not lead to a claim for damages for nervous shock. Now, when we got to Novo, Lord Dyson did address this and disagreed with it. And the Court of Appeal conclude that Lord Dyson seems to have expressly disapproved the concept of a claim for psychiatric injury by a close relative in a clinical negligence case. So what the Court of Appeal says, we hear what Lord Justice Peter Gibson was saying. However, we're stuck by what Lord Dyson was telling us in the case of Novo. And in that case, he pretty much said we don't get secondary victim cases in clinical negligence where there isn't a violent event all at the same time. And so their decision is this, it's summed up really in one paragraph, which is that the decision in Novo was that the 5 elements could not be extended to allow a secondary victim to recover damages for psychiatric illness if the horrific event occurred months and possibly years after the accident. Lord Dyson didn't need to delve into the timings because that's not really what he was dealing with. He clearly approved what was decided in Somerset, which was, in my judgment, however, he clearly approved what Judge Old had decided in Somerset, which was a clinical negligence case. And he made clear that 5 elements did not allow recovery for anything that occurred beyond the aftermath of an accident. And more specifically, he held that there was no qualifying horrific event where the primary victim's heart condition caused death months after. And so the position we're in is really the Court of Appeal is saying we're completely bound by everything that's happened before. They fully studied all of the decisions and couldn't find flaws in them legally. What they said is this is the natural progression of secondary victim cases, and we cannot disagree with a different Court of Appeal decision because we're bound by it. But we have those huge nods that we should be going to the Supreme Court over these types of issues. So where does that leave us? What's the effective summary that you can really take away from the case of Polmear and Purchase? And I think these are probably the simplest bullet points. That the 5 elements from Alcock do apply to clinical negligence cases. So that's where Gareth started our talk. They all apply. There is no requirement for an external traumatic event. So though it's been discussed, the Court of Appeal in Paul were very clear that that's not in fact required. In terms of how we assess, the primary victim's cause of action is not the critical thing. We're not working out what their journey in negligence was, it's what the secondary victim witnessed. However, the horrific event cannot be a separate event removed in time from the negligence. Novo is, in fact, a binding authority. But we have a very small window as clinical negligence lawyers for claimants, or indeed for defendants to be boxing off, which is if the horrific event and negligence are part of a continuum, there is a sufficient proximity. And really, that's as much as we get from the Court of Appeal as things stand now. That's the best explanation we get of Walters, which there was a 36-hour continuum. It's not specifically said that was wrong when Novo was decided. So that's where we're left with a very small window of continuums, and meaning it's going to be quite difficult for claimant lawyers moving forward in secondary victim clinical negligence cases. So having heard me for quite some time summarise Paul, I'm going to hand back to Gareth to round up of where we can leave you.
Thanks, Megan. So just before we do, 2 things. One is that Megan touched upon this idea of not focusing on the primary victim when dealing with secondary victim claims. It's almost always the case, of course, that there is a primary victim, but the cases do comment on the idea that the focus is on the relationship. It's not an adjunct relationship between the defendant and the secondary victim because there is a primary victim. It is a standalone duty of care owed by a defendant to a secondary victim in which the control mechanisms have to be satisfied. They give an example of a primary victim, let's say a child, looking as if they're about to be hit by a car, the mother witnessing that, but the child not in fact suffering any injury, and psychiatric or otherwise. So there's no complete cause of action. There is in fact no primary victim, but the secondary victim, the mother, believes or thinks that the child is about to be hit, suffers a sudden shock because of that, suffers psychiatric injury, and provided they satisfy all the other criteria, could in theory claim as a secondary victim, even though there is in fact no primary victim. And the second thing was about the Walters case. It seems that nobody's quite satisfied, some of the authorities, neither in Novo or in Polmear, quite how Walters fits in and whether it's an outlier or not. And there's actually a throwaway remark, a throwaway line almost from the Court of Appeal in Paul about Walters, which is that they say, as Meg has described, that if the negligence and horrific events are part of a continuum, that might be the best explanation for Walters, then that would satisfy the proximity test. And then the judge says, it may be that the negligence was continuing in Walters at the time the 36-hour shocking event began. And that's sort of passing remark, and then it goes, either way, Novo is binding. But it occurs to me that's probably really important, because of course what you're talking about is, well, when is the negligence for the secondary victim occurring? Did it cause the shocking event to occur? And has actually psychiatric injury been caused by it? Because unless you satisfy those criteria as a claimant for the purposes of a clinical negligence claim, you're likely to fail. So turning to this working checklist, you either are defending or pursuing a claim potentially on behalf of a secondary victim, what's a proposed thought process? Well, firstly, again, going back to that point, focus on what's the horrific event giving rise to the psychiatric injury. Is it a one-off matter? Was it something that the claimant, potentially the mother or the father, potentially of a child, let's say, at hospital, is it something they were told? If it's what I refer to as an information case, if they're simply told about the incident that then causes the shock, well, what is the horrific event? It's not enough to simply be told of something in order to then say, well, that was a horrific event for whoever witnessed it, and we were told about it, and it has caused us to suffer from nervous shock. So what's the first question is, what is the horrific event that the claimant says that they witnessed and that caused them to suffer the sudden shock and giving rise to the psychiatric injury? Next question, well, was that horrific event caused by the defendant's breach of duty? That's just the usual analysis that we all have to undertake in the course of assessing clinical negligence claims. Third, critically important, is there an interval of time between the breach that caused the horrific event and between the breach and the horrific event? If there's not, the claimant would likely succeed, subject, of course, to satisfying the other control mechanisms. If there was an interval of time, was that interval of time one that can be explained as a seamless continuum a la Walters? If not, the claim is likely to fail. That's the sort of thought process that we would suggest that you can adopt on the current law as it currently stands prior to the Supreme Court weighing in. And the upshot, the headline is, as the law stands, there will be very, very few cases under which a claimant as a secondary victim is likely to succeed in a clinical negligence setting. Megan, I think there's one last slide. Crystal ball gazing time. What's going to happen at the Supreme Court? We, of course, have no idea. But the reality is they're going to be facing the same issues that the Court of Appeal faced. First question will be, well, is Taylor and Novo still good law? Is that the correct interpretation of the limits imposed by means of the control mechanisms arising from the Alcock case? Is it a matter of the immediate aftermath and no further for the purposes of a horrific event giving rise to nervous shock? Or can there be an extension of time beyond the horrific event for the purposes of the claimant succeeding? Second, is this interval of time critical? A number of the Lord Justices in the Court of Appeal in various different cases have criticised this. Well, what's the fairness here for a claimant that is there and present at the time that the breach occurs, succeeding, but then a period of time passing, maybe a week or so passing, the same event occurring, same horrific event occurring, but there's a period of time between the breach, between the negligence and the actual horrific event and failing. Why should that be as it is? And thirdly, should we separate the idea of clinical negligence cases fitting within the Alcock control mechanisms like the personal injury claims have to? Should they be separated or not? Those are some of the things that I anticipate, Megan and I anticipate, probably will be addressed by the Supreme Court. Until then, the law is, as the courts have said it out in Paul and Polmear. What that means for cases on your desk, of course, for the purposes of assessing risk, is to decide, well, are you going to be pursuing claims on as the law currently stands? When is the Supreme Court going to add risk to those who are defending claims? Will it change the law? Will the Supreme Court say, we throw our hands up just as much as any prior Court of Appeal case has done? We don't like it, but we're in no position to change it. If there's going to be a change, it has to come from Parliament. We're stuck where we are. And an incremental approach out of the position we're in is not the right one. We, of course, don't know, but those are practical matters that you'll have to assess in your cases until that happens. We try to be less than an hour. We've been less than an hour, even allowing for the technological problems at the start. Megan, is there anything you want to add for the purposes of this question as well? What are the issues that the Supreme Court are going to deal with?
I don't think there's anything separate from me other than to say the second question of should the interval of time matter. There's a lot of commentary in the cases that secondary victim claims have progressed because of what would the ordinary person expect to be reasonable and just for these types of compensation. So I think the should questions are probably going to be quite important to the Supreme Court, because we do just hark back to the Hillsborough disaster, and that's where it all came from. So really, we seem to be looking at the justice question as to whether they should be allowed or not. But it will be interesting when it's eventually decided.
Great. Okay. All right. Well, everybody, thank you so much for attending. We do these Law with Lunch talks regularly. Please sign up to the next one. And any feedback, if you want slides or if you want any questions from Megan and I about this, please just email us. We'll be happy to help.
Thank you, everybody.